to the Civil Practice Act. The issue is redaction of personal identifying information in documents filed with the court, and that would be information such as a Social Security number, taxpayer ID number, a bank account number, credit card number, things of that nature. They're all listed there in subsection A. We have put a kind of a special Georgia twist on Rule 5, and so what we're basically doing is importing Federal Rule of Civil Procedure 5.2 into the Civil Practice Act and designating it after the first code section in the pleadings and motions part of the Civil Practice Act. So it would be the very second code section, and it would become 911-7.1. It's not exactly like Rule 5.2. We've definitely put more of a Georgia twist on it. The key to a lot of the rest of the provisions in the bill is that the clerks don't want to be responsible for redacting information on their own, and so we are making it so that if, for example, unredacted information that was supposed to be redacted pursuant to the rule is filed accidentally, then the remedy for that is for the court to order that filing be sealed, and then the court could also file an unredacted version of that same document. But basically the court becomes the gatekeeper of what is sealed and what is not sealed in the record. We had a rather vigorous discussion in subcommittee over the issue of the first part of this really was not an issue, and that is making sure that when something is filed and accidentally something was not redacted, that can be cured, and that it doesn't end up, if you're filing, say, a complaint with some personal identifying information in an exhibit, that doesn't preclude you from actually making the filing at 4:55 on the last day of the statute of limitations. And then we've also added some language there, I think on lines 36 and 37, that it also doesn't preclude you from going ahead and filing the document with the court, and that the remedy for that, of course, then is sealing the record. We have also, there's been some communication after the bill between subcommittee and full committee, and so you have a substitute here, LC 295961S, that exempts probate court filings from the operation of the rule because of the types of filings that they generally receive in probate court. But then in thinking through that, we also decided to expressly add in magistrate court, given that we see a lot of debt collection filings in magistrate court on credit card debts and loans and things of that nature that do have tend to have Social Security numbers and account numbers in those documents. And so there on lines 51 and 52, you'll see a cross-reference to the part of the code to the part of the courts code, Title 15, that deals with magistrate courts. And then you will also see a reciprocal cross-reference in Section 2 of the bill, in Section 3 of the bill, that makes the new Rule 7.1 expressly mentioned in the part of the magistrate court code that exempts the magistrate courts from the operation of the Civil Practice Act. And then the last thing is, there in Section 2 of the bill, we are requiring, in essence, an express checkoff on the civil case filing form that's filed at the outset of the case, that the party filing the pleading acknowledges that they have followed the requirements of Rule 911-7.1, and that is very similar to what we have in federal practice, where on ECF, when you file a document, you have a little checkbox that you have to check when you sign into ECF in order to proceed to file the document. So that, in a nutshell, Mr. Chairman, is House Bill 977. I do have about 3 words that I want to strike from this version of the bill via amendment, just to clean it up, but otherwise I think we're ready to go.
All right. Questions by members of the committee of the presenter? Yes, sir. Mr. Mabry.
Thank you, Mr. Chairman. Representative, I just wanted to make sure that any filings that you take to the clerk, if it does have something that's not redacted, they will accept those filings. There's no ifs, ands, or buts about that now.
That is absolutely correct. Even though, much to my consternation, we added an amendment in subcommittee that we had a little debate over that issue, as you'll recall. But I have respected the will of the subcommittee on that issue, and so the language is on lines 35 through 37. An inadvertent failure to redact information which is required to be redacted shall be a curable defect and shall not preclude a document from being filed with the court. Period. And that's what the subcommittee decided to do.
Thank you, Mr. Chairman.
Other questions by members of the committee? Mr. Fleming.
Thank you, Mr. Chairman. So right now, if you today filed something in court with somebody's social security number, for example, or a financial number, and from that court filing, something bad happened, somebody got a hold to it, and did what we see quite often, they steal somebody's identity in some form. Am I to assume that obviously the person who committed that crime can be punished, but what about the person that filed the document with the court? And here's why I ask that. Am I assuming that we're enhancing restrictions on what can be filed with the court? Is that correct?
That's correct.
So are we creating any kind of additional responsibility, thus possible action for negligence, is getting somebody who does not redact properly, because we're putting expressly in the Civil Practice Act now what you do have to redact?
Correct.
Does that make sense?
That makes sense.
So you think we are creating probably a duty here?
I think we're absolutely creating a duty here. Now, I mean, you have to recognize that there are going to be instances of inadvertence, and you know, we have done our best to accommodate in the new code section remedies for that, to make it possible to quickly get that document sealed, and if necessary, file a new one, you know, that's that is redacted. But yes, I think that the direct answer to your question is yes.
And we're doing that because there's obviously a need for this perceived?
I think there is a need for this. There is no rule on point that governs civil practice on this issue in state court.
There is in federal?
There is in federal, 5.2. And in fact, this is an importation of the federal rule of civil procedure into the Civil Practice
And I know
Act.
you made those distinctions in your description as to some of the things we're doing differently under the Georgia Code section. So, to the extent that this differs from the federal rule, what is the biggest distinction? And I'm trying to give the analysis that there's a true and tried method, and evidently the federal rule has been around for a little bit. And I'm trying to see how we're deviating from that, such that we're creating something new, and how that might work.
Well, I mean, I would say that the biggest distinctions are going to really relate to are really going to relate to how functionally the filings occur in a clerk's office. I mean, I don't. You know, that's where we made kind of the biggest departures from the federal rule. I mean, the bottom line now is that the clerks are not responsible for judging whether something is properly redacted or not. They just accept the filings, and ultimately any correction of problems that are created by filing an unredacted document that should have been redacted, you know, the court ends up being the gatekeeper for all of that. I think this is much more prescriptive on as to those sorts of procedures than the federal rule is. I think that's the biggest departure.
Thank you.
Any further questions by members of the committee of the presenter? Is there anyone else in the audience who wishes to address the committee on HB 977 at this time? If not, we will suspend further public comment. The bill is now in the breast of the committee. Is there any discussion among members of the committee regarding 977? If not, the chair will entertain motions. We got a motion by Mr. Jacobs, seconded by Mr. Weldon. Do pass. Discussion? Yes, sir. Mr. Do we have any amendments?
We do. This was kind of late added after subcommittee language, and I just want to clean it up a little bit. There on line 41, delete the words subsection A of. And the reason for that is that really subsection A, the information that is required to be redacted is really subsection A modified by other portions of the code section, especially subsection B. So I think just by making that a cross-reference to the code section as a whole, that makes the most sense. So strike subsection A of on line 41.
All right, we have a motion to amend on line 41. This will be the Jacobs Amendment. Do we have a second to it? Do you have a second? Yes, ma'am. Ms. Evans, all right. Any discussion on the amendment? Chair will take up the amendment first. All in favor of the Jacobs Amendment signify by saying aye.
Aye.
Opposed, like sign. Motion carries. Do we have any further amendments? There are no further amendments. The chair will call the main question, which is motion do pass HB 977 as LC 295961S. All in favor signify by saying aye.
Aye.
Opposed, like sign. Motion carries. I neglected to point out we have with us today some jurists. Judge Catherine Goslin from the Gainesville Court, Superior Court, and hiding behind the pole here, the big support pole, we have, I believe, Judge Tripp Self of Macon, Bibb County Superior Court. Thank you both for being here. I think, Judge, did you deliberately get behind the pole so you didn't have to look at me, or is it? It's a good reason. But, Judge Goslin, I believe you're the incoming president. If I no, who's incoming? I forgot. That's it, Judge Staley from Cobb County. My mistake. Well, thank you both for being with us today. We hope we entertain you. I'm going to take up the. My plan is to hold up on the as a matter of the e-discovery as the last matter, because that will be something we do within Justice Committee. We're not going to have any more public input on the e-discovery. We've completed that. We have some amendments done. We had a redraft in the bill. There's several other amendments we're going to be looking at. But I will at this time go to, is Mr. Pack here? Mr. Pack still not here? Would somebody please call him and see if we can get him here? And Mr. Welch, not here either, is he? We have Mr. Powell's bill. We have HB 504, Mr. Williamson. Impact, that's who that is. Okay, excuse me. We just did Jacob's bill. I need to have some people here to take the bills, or we're going to be in a problem time-wise. Ms. Lindsay, you want to do 438? For Mr. Powell? Sorry? Are you... Now, Mr. Powell said he would be back here. I just... All right, let you go ahead and present on behalf of Mr. Powell. HB 438.
The only thing that HB 438 does, Mr. Chairman, is found on line 12, is that it increases the maximum fee up to $10 as opposed to $7.50.
For what?
For an alternative dispute resolution program, but some not to exceed $10 in addition to all other legal costs may be charged and collected in each civil action or case filed in the Superior State Probate yada yada.
Yes. All right, thank you. That's your presentation.
I like the yada yada.
Yeah, yada. Right. Mr. Caldwell, I think you, or was it you, or Ms. I'm sorry, Ms. Oliver.
I was going to help him a little bit.
Please help. He obviously, you brought it up for him to do it. So.
I didn't want to volunteer myself. I thought I didn't want to be too presumptuous, but I will help you a little bit. This is an AOC bill, and this fee has not been raised since 92, 3, something like that. Most of the districts, 40-something plus districts, do impose a fee, and all the county budgets have been cut. In DeKalb County, we've cut DeKalb County Finance's ADR out of its budget, but we've cut the hours, so I think it is a timely addition, and we all know how much ADR saves the court and the taxpayers. Does that help?
Not only does it help, but it explains the necessity of the bill. Mr. Chairman, at the due time, got a motion.
All right, I think the other thing that I've heard about is that the course filings have dropped off in the last several years, which is maybe a good thing. People may not be as litigious as they used to be. So that's been a need of having to continue the fact that dispute resolution is resolving a lot of pending cases. And with that, there's no further public. Anybody wish to speak on the bill in the audience? Yes, sir. I'm sorry. You wanted Mr. Clark. Or you come forward.
From the, judicial.
Come on, have a seat. I know you like to be on TV.
May it please the Chairman and members of the committee, I'm Mike Kikero. I represent the Judicial Council and the Administrative Office of the Courts. We do support House Bill 438. There are a number of alternative dispute resolution programs across the state serving 121 counties. What they have seen is exactly what has been explained, that the money that are coming in from fees are declining and the trust funds are being depleted slowly. This fee, which has not the cap has not increased for many years. It's not, the maximum is not charged everywhere, but it would be a great help to a number of programs that are in trouble. Thank you.
Question.
Yes,
Anybody
sir.
have questions? I'd like to ask if I can, Mr. Carl, do we have a figure of how much we are been having come in through these filings on a statewide basis? Do you know what that sum would be?
We did a survey of 21 of the 43 programs, and I have some examples from different programs in the state. Reported revenue from Chairman Powell, he's the sponsor. That program received $136,844 last in 2012, but the difference in revenue, or the decline in revenue from that year, was $43,000, which is, rough math, 25%. Gwinnett, which received in that year $293,000. That was $123,000 less. So it's a substantial reduction year to year.
Very well. Thank you, sir.
Yes, sir.
Mr. Clark.
Thank you, Mr. Chairman, members of the committee. Bill Clark on behalf of the Georgia Trial Lawyers Association. As we have said to Representative Powell for 2 years now, we oppose this bill. Most of you will recall 4 years ago, there was a massive increase in the filing fees, over I believe it was $125 added to that. The routine filing fees went from something in the neighborhood of $85. It's now close to $250, and with certain add-ons in certain cases or certain counties, it can be closer to $300. We as society benefit from a well-working civil justice system. But all of we in society benefit from that, not just the litigants and not just the plaintiffs. And yet this is a filing fee that only plaintiffs have to pay. It also pays for government-run ADR. We are huge proponents of ADR. But ADR is being provided in most of the state by wonderful private enterprise operations. There are large firms popping up all over the state to provide these services. I've heard around this building over the last 10 years, why should government be providing a service if private enterprise is providing that service as well or better? And yet we have this old program of government-run ADR, and we would suggest that perhaps if we are having financing problems for that, then maybe the best solution is to save all the money and not charge the taxpayers anything for a government-run service that is being provided very well by a private enterprise. I know I'm swimming against the tide on this one. We all want to help our local courts, but I would submit to you, if our local courts need more funding, then let's appropriate that funding and let all of the citizens who benefit from those courts share the load rather than placing it just on plaintiffs in civil filings. I'm glad to answer any questions. I appreciate the opportunity to speak today.
Thank you for the presentation. Any questions of Mr. Clark by members of the committee? Yes, sir.
Thank you, Mr. Chairman. Of the $7.50 that's being paid now since 1990, whatever, does the $7.50 go totally to, or does where does the fee go to?
That's a great question. When we were looking at that filing fee bill 4 years ago, that question was asked over and over, and it would be great. I know the counties have made, I think, the good argument that these filing fees don't come to our coffers. They go to the state, or some of them are designated. I don't know about this one in particular, but we are taking in place of appropriately appropriating, we're calling it a fee so that nobody has to answer for appropriating, charging more of the taxpayer.
I guess does the entire $7.50 go to the ADR program, or does it? Who decides? I mean, I'm just curious.
There are others behind me probably who can answer that better than I.
Yeah. Mr. Vaccaro, you want to chime in on giving a response to that from the Administrative Office of the Courts?
Yes, there is right now the statutes say that there's a maximum of $7.50. Not all programs charge that. For instance, Gwinnett charges I think $3 as part of their fee, but there are others that charge the maximum. But there's a range of different ranges of services. Gwinnett provides some services, or others that have richer services. Some of them, when I say richer, they provide more services. So, for instance, mediation for indigents. Sometimes the cost is defrayed through that. Another program which serves the 9th District, which is, Judge Goslin's at about 15 counties? The 9th? Okay, more than 15 counties, but they actually provide the divorcing parent seminar through this program. So each locality determines what services they want to provide and then attune the rate that they charge accordingly. So it varies throughout the state.
Let me ask a question to follow up on that. Does every county have some form of alternative dispute resolution program, as stated in the Act?
My figures are that 121 counties do, and the rest don't.
So where they don't have it, they don't collect the fee.
And didn't you quote an example of Gwinnett? Didn't they collected like 100-something thousand less?
Close to 300,000 they collected, but that was $120,000 less than they had the year before.
And they're not charging $7.50. They're charging
$3. That's what our study tells me. So
I recommend them charging $7.50.
Ms. Oliver?
I don't know how many districts are at the 750 and need to go, or in the high volume counties like DeKalb, where almost 60% of the people are coming in without lawyers. The whole court system relies on ADR to manage the folks without lawyers, and
We might want to ask questions if you want. We'll have a discussion.
Isn't it true?
Is it true?
I wanted to answer.
Thank you, Ms. Oliver.
I wanted to answer.
I'm going to. I'll recognize you for a discussion. Believe me, Ms. Evans.
Thank you, Mr. Chairman. If you said this earlier, I apologize that I just didn't hear it. I'm assuming there must be courts that are at the max, though, or this bill wouldn't.
Yes, quite a few.
Okay.
And there, for instance, let's take the example of DeKalb County. In 2012, collected $520,000. That was $240,000 less than the year before. I mean, they're watching the trust fund in DeKalb County be depleted, so that there has been quite a bit of money in it, but it's being depleted at a rate that in a few years, very few years, they believe they might have to cut services, and it does. We can look through. It does quite a bit in DeKalb County.
Is there anywhere else though besides DeKalb that's at the limit?
I've got among the 21 that we looked at, the 9th Judicial Circuit, which is over 15 counties. I've got the Southern Judicial Circuit. I can't remember how many counties that is. DeKalb, Fulton County. Okay. Those are the ones I have listed at the maximum.
Mr. Weldon.
Thank you, Mr. Chairman. And I may be asking this a little bit out of turn. It seems to me that these fees, when they're collected, do they stay in the county, or they go to the state?
They do not go to the state.
Okay, then I'll have it.
All right. Further questions of either Mr. Clark or Mr. Vaccaro? Ms. Clark, you want to have the final word on this?
If I may, Mr. Chairman, if DeKalb County or any other county's court system needs more funding, then the DeKalb County Commissioners need to appropriate that funding so that all of the citizens of DeKalb County bear that burden rather than just the plaintiffs. The civil plaintiffs are carrying the load for everybody. If it's a benefit to all of the county, why shouldn't all of the county citizens, and the same goes for municipal courts, why shouldn't they bear the cost rather than just the plaintiffs? Thank you, Mr. Chairman.
Yes, sir. Thank you. Does anyone else wish to address the committee on HB 438? If not, we will close all further public comment. It's now in the rest of the committee. Do we have discussion, Ms. Oliver, among members of the committee about the bill?
When I have a client who can pay a $300 to $500 an hourly fee for a private mediator, I'll hire a private mediator. But that's not the usual client. The usual client that can't afford any lawyer uses mediation services. It is a cost saver for the taxpayer in the short and the long run. I think litigants should pay their freight. And I think Mr. Clark has a good point about the defendant doesn't pay the $3 or the $10. And how we fix that is where we should be bringing our attention, but not in not funding mediation through the participants and who have to take or choose to take their issues to the court.
And Ms. Evans, or is it Mr. Jacobs, excuse me, you want to?
Yeah, I mean, I would concur. First of all, I mean, I think these are valuable programs, particularly in a county like DeKalb. I understand Mr. Clark's concern, but at the end of the day, I would much rather consumers of the judicial system be carrying this burden than the DeKalb County government to plug a hole in the ADR program, be raising my property taxes to do it. So I respectfully disagree with the approach. I think the better approach is for the burden to remain within the within the pool of litigants in the court system and support the bill for that reason.
And Mr. Weldon?
I guess I'll need to pose this to you, Mr. Chairman, if I could.
Yes, sir.
It's the fact that the money is staying in the program in the counties, but the fee is set by state law. It would seem to me that this money should come back to the Treasury of State and then be appropriated accordingly from the state. Is that?
Well, the danger you have there is goes into the general fund.
Yes, sir.
We do fees now that come to the state. And unfortunately, they go into the general fund. It doesn't mean it all goes back to the program designated. Can I bring you to mind with the Indigent Defense Program, which has special filing fees that are not totally used in that program, have not the last several years anyway.
Yes, sir. And that's part of my concern about how these funds are being allocated. If these monies go back to the county, and the county has bylaws or local legislation that requires it to be go to a general fund and then appropriated just like we do here at the state level, then what could be happening in those counties that are seeing those, apparently goes into a trust fund, but I'm not sure I follow how the money goes from the court clerk that receives the funds and how it is moving around and getting back to the trust fund. And yeah, that's my question.
Yes,
on how that works.
Might have been a good question to ask when we had public input from Mr. Kakaro. At this point, next was over here. You wave, all right. And we have, yes, ma'am, Miss Pam Stevenson. No, I don't think it goes down to dispute resolution as a matter of recorder's courts.
It doesn't include magistrate either, I don't think.
It says magistrates. I know in some magistrate courts they do have somebody that does dispute resolution for them during court times. Anything further, Ms. Stevenson? And back to Ms. Oliver, that's you? No, excuse me. Any further comments, discussion among committee members? If not, the chair will entertain a motion to House Bill 438.
Second.
Motion is due pass with a second by Ms. Oliver. Any further discussion? Any amendments to the motion? There being none, the chair calls the main question, which is due pass motion. House Bill 438 is LC 21-2105. All in favor of the motion signify by saying aye. Aye. Opposed, like sign. Aye. One no, and chair rules the motion carries. Bill passes. Recommendation. Thank you. Mr. Pack, we're here now on House Bill 504 by Representative Pack. You got your mic on, you're all right?
Thank you.
One of them.
Thank you, Mr. Chairman. And members of the committee. I've been before several of your subcommittees, and so I appreciate the time. I'm working off of LC 295954S. I want to make sure.
Correct. You're right. Okay. There's one in our folder. Everybody has that copy of the folder. First of all, I think I've spoken to many of you, and I've appeared before your subcommittee several times about the issue of the admissibility of non-seatbelt use in very limited circumstances. And this is the culmination, the substitute that you have in front of you is culmination of taking input from all of you and plus the various interested parties. Let me start off by thanking various members of the committee, especially Chairman Willard, for his insight, and also Chairman Fleming and Representative Oliver, Representative Caldwell, Representative Evans, and Representative Jacobs on the input on this bill. Let me just briefly state, it's a late hour, about the policy reasons behind this. We are a apportionment of fault state. So in any case, the jury gets to decide how much to award or portion in terms of damages and fault. In this area, in traffic accident cases here, the law is currently written so that in an accident caused by a negligent person, if the plaintiff or the person who's injured in that case was not wearing a seatbelt, the evidence of non-use of seatbelt is not admissible under any circumstances. What House Bill 504 is trying to do is give that relevant fact under limited circumstances to the jury so they could actually follow the apportionment law as we have written. I know there were several concerns about whether or not it's prejudicial or fair to actually omit that evidence. I think the substitute in front of you actually has a careful, it's a careful, balanced approach to making sure there's not going to be abuse of use of non-seatbelt defense. Just to clarify a couple things, it's changed from previous version of the bill. One, the language currently, the meat of the language is actually in line 17 through 24. Basically, it requires a finding by the court prior to the jury getting it, requiring finding by the court that by clear and convincing evidence, not the evidentiary threshold of something relevant, the court has to find by clear and convincing evidence that the person was not wearing a seatbelt and was of age of 18. Now, the previous version you might have seen started at age 14. We obviously, as a compromise, raised that to 18. And the threshold finding that the court needs to make went from just a regular evidentiary ruling to actually making a finding of clear and convincing, which is a high threshold. That's to kind of alleviate some of the concerns that some may trying to cut down to the potential abuses of that defense in cases. The second thing, the unique thing about this substitute is in line 25 and through 28, and this was actually amendment proposed by Representative Oliver to put some timelines onto when you can send notice and file a motion for making a finding of the hearing. And the language is reflected that prior to 30 days of end of discovery, ending period of discovery, the person seeking or the party seeking to use or introduce evidence of seatbelt non-use has to file a motion to put people on notice. And rest of the current existing law doesn't change. The failure of using a safety belt can't be used to cancel any insurance or increase the rates.
And I'm sure you're very familiar with this issue, and I'd be happy to answer any question. I'm sure there's a lot of people who wanted to speak on this bill.
I'm sure there are too. If I might take the chair's prerogative, I have a little concern about the filing a motion within 30 days prior to the end of discovery. For one reason, you don't know when discovery is going to end, so are you properly filing it if there's an extension done for discovery? Most other things we have where we talk about something being filed related to a discovery date is within 30 days after the end of discovery. Would that not be a better way to do it as far as recognizing discovery has in fact ended and now you got to do something within that 30-day time frame?
At the subcommittee level, maybe it was ambiguous if the intent was after 30 days to be definitive. I don't view that as I would be welcoming that change to the, I'd be open to amendment on that,
All right, let's
Mr.
keep
Chair.
that in mind just as a practical matter. I think the first person who wanted to ask you something is Mr. Lindsay.
Well, you touched on one, which is, I think it makes more sense, whatever time period that you want to mandate for someone to file this motion, it should be after the close of discovery, not before. I don't know if 30 days is really, I don't know if it's really quite 30 days, but whatever the time period we arrive at, it ought to be after the discovery period rather than before. The second question I have is, I want you to kind of walk this through with me. The way it works is that the judge is going to determine whether or not the person was wearing a seatbelt or not.
Right. He or she would have to make a preliminary finding that by clear and convincing evidence the person is over the age of 18. In fact, that there is evidence for them to find that that the person was not wearing a seatbelt. Now, there was a question during subcommittee about whether or not that would be like an estoppel that be used as a conclusive finding by the jury. That's not the intent of the bill, and certainly the way we drafted the language, the jury gets a fresh look. They could reject it if they want it, or
well, I guess that's my question is, what is the jury going to be rejecting? Is the jury rejecting that they were wearing the seatbelt, or is the jury accepting or rejecting the fact that they were damaged as a result of not wearing the seatbelt?
Well, those two issues, what the jury will find. In order to find that the injury was caused by a lack of use, they would have to find that the person wasn't using a seatbelt. What I'm saying is the judge's finding by clear and convincing evidence only relates to the admissibility. So that fact's not going to come into the jury. The jury could, de novo consider the evidence and reject all of it if they wish.
So in effect, the judge is let me just say, I think it makes, does it not, is it not true? It would appear to make sense to make it clear and convincing if it was then going to be determinative in terms of the wearing of the seatbelt. I do understand it's still up to the jury to decide whether or not the wearing of the seatbelt did or did not have an impact on the damages. But to have a clear and convincing level and then still leave it to the jury to again then decide by preponderance of the evidence whether or not they're wearing a seatbelt or not, quite frankly, doesn't make any sense.
I don't, may I respond? I don't think the second part of your question even gets to a jury for determination. If the court makes a decision, let's assume the decision is, I don't believe there is sufficient evidence, under clear and convincing evidence, and I'll say this somewhat like a bar put up here on summary judgment, that the court considers a matter of law, but this is now looking at a factual issue, that it says, I don't think there's evidence to have you defendants speak of not wearing a seatbelt because you haven't met the threshold requirement. So now the law is back as it currently is, which is you cannot bring in evidence or mention that the seatbelt, whether it was being worn or not, unless the person has admitted it, of course.
Mr. Chairman, my question is, if we're requiring a clear and convincing level just to determine by the judge to determine whether or not they're wearing a seatbelt, why are we? Let's back up. According to, if I understand how this thing is going to work, clear and convincing evidence determined by the judge that they were not wearing the seatbelt, and then we're going to allow the jury to determine by a preponderance of the evidence whether or not they were wearing a seatbelt. Is that right?
No.
So, all right. Well, that's what I want to make sure.
That's my point. It's all decided by the trial judge on the issue of admissibility or not of did you or did you not wear a seatbelt.
gets to my question, Mr.
All right.
Chairman, and to the author of the bill. If the judge determines that that he or she was not wearing the seatbelt, is that then?
There's no evidence to be allowed to come in. It'd be like the current law is today.
No.
Okay.
If the judge determines that they were not wearing the seatbelt.
Right. Oh, they were not. I'm sorry.
Okay. Is that then determinative, and then it's up to the jury to determine whether or not they were
It's
injured as a result of not
mitigation of
wearing the
damages, right? Mitigation of damages.
All right.
So that's a step the jury would consider about should the damages be reduced because they have violated the law that directs them to wear a seatbelt.
So then the only thing the jury's going to determine is whether or not the not wearing of the seatbelt did or did not injure it. Did or did not
No.
aggravate the
Mitigation of damage, right?
Okay. All right.
That's next question. I'm going to come to Ms. Oliver.
To your first point, I remembered our motion was after the end of time allowed, but I'm wrong. But
At least it's worded different, maybe in your plan, but we can get it. We'll get it corrected.
okay, so
We'll
I
get
think
it corrected.
I think you're right about after. That's the only point.
All right. Next we have over here, is that Ms. Evans or?
Thank you, Mr. Chairman. My question is about what we were just talking about when the person makes a motion to have a hearing in front of the judge on whether the person was wearing their seatbelt or not. And my question may seem, I may just be wrong. I've never handled a car accident case, so I don't know how it works, and I've never had a state court case that went as far as experts in the discovery period. But I know in cases I've had in federal court, I couldn't designate an expert after discovery was over. So I'm envisioning, and my question is how you would address this scenario. You have the hearing. The court says, yes, clear and convincing evidence, the plaintiff was not wearing his or her seatbelt. So I'm going to let that evidence go to the jury. Then as the plaintiff, I don't have the opportunity to designate an expert to rebut any testimony that the injuries weren't caused by the seatbelt, or alternatively, the plaintiff has to hire that expert before we know if that evidence is going to go to the jury, and therefore incur a lot of expense that may not be necessary if there is no finding. So that's why I think, but the question is,
Maybe
could you handle it?
Maybe prior to entering a pretrial order?
Or, Mr. Chairman, perhaps for consideration that if there is this finding, there is a 30-day period or some period of time allowed for experts to be obtained and discovery taken from those experts on the issue of what happened to what caused the injuries.
But we actually considered that in the subcommittee. As a matter of fact, what ended up happening was we didn't want to control exactly what the judge could do, and I think he or she has power to do that. And it's a high threshold, so if they meet it, certainly I'm sure that the judiciary and the judge would consider a request to find an expert to rebut that.
Well, one follow-up if I can,
Sure,
Mr. Chairman. I could also, though, do you agree with me that there might be a scenario where a judge says, you knew this was a possibility, that my finding could be yes, and sorry, you didn't go get your expert. Tough luck. We're going to the jury, and you've got no expert. But there are there's good judges out there, don't get me wrong, but sometimes you guys can be tough.
All right.
And Representative Evans, that is a good point, and we did consider that in the subcommittee. One thing that we did realize is if someone's going to make a showing up to clear and convincing evidence, it's going to be abundantly clear that they're obtaining an expert. I don't think that if that finding is made, I don't think it'd be very hard to anticipate, that potentially you might need an expert in that case. And the testimony was, in discussion, was the use of this defense. I think it'd be very clear early on in the discovery period whether or not there's a potential challenge to whether or not someone was wearing a seatbelt, because deposing the victim is one of the first things that the defense lawyers do after obtaining medical records. But you do raise a point and potential that the judge might not allow it.
I think what you'd have is, you might play through the scenario. Think about it. If the court rules yes, there's evidence the person was not wearing a seatbelt, that's going to go as a matter of mitigation of damage. You still have the right. You're not precluded from getting witnesses. Right. You're not precluded from getting witnesses until you have a pretrial order, and even then, there could be a need of a surprise information coming up to ask the court to open it up. So once the motion is made, the ruling is made, if there's need to get expert testimony, you still have the ability to do that. And I think the other side would have a right to go through discovery of that new witness. So I'm not saying it's an impossible barrier. Over here we have, I believe, Judge. No, you again, Mr. Aldridge. Excuse me.
Yeah, Representative Evans and I have something in common. I've never handled it. So my question is, like the other day in the subcommittee, waiting 30 days after the discovery. When is the discovery period set, and how long is the discovery period? 6 months.
Generally 6 months.
All right, 6 months. Why wouldn't we do this in the first 30 days?
Once again, I think the general, and that's a very legitimate point, Representative. But I think the fact of the matter is we wanted to leave it to the discretion of the judge, and counsel could decide whenever we want to do that. We didn't want to dictate timelines when that could be. It would be self-determinative of when you're going to assert it. And so the only deadline we talked about is by when are they going to know, give them enough time when they're going to know that they're going to assert the defense. And so the 30 days, I'm sorry I misunderstood. I think when we wrote it down, we had an ambiguous word in there before. I think the intent was to give them, after discovery closes, within 30 days to determine whether or not they're going to do that. Instead of mandating a deadline early in the discovery, that would dictate how they conduct discovery, which I don't think is a good policy.
All right, back on this other side, Mr. Weldon.
Thank you, Mr. Chairman. Mr. Pack, in your bill, if it becomes law, my concern is that one side or the other, plaintiff or defendant, could conduct themselves in a manner that's not very conducive to the orderly litigation of a lawsuit in this case. Would you be amenable to an amendment to your bill on the second page? And I've included a substitute that includes this amendment. It's LC 295950S, and the only modifications it makes on the second page, beginning after the words, on line 28, after the words, a hearing regarding these issues, and then there's a period. The additional language that I would ask for is that if these issues are not resolved prior to the hearing on such motion, the prevailing party may be entitled to recover from the opposing party reasonable attorney's fees and expenses of litigation incurred in connection with litigation of these issues. And what I think this will do is this will put pressure on both parties, plaintiff and defendant, equally to address the issue if this is part of what's going to be part of the case or included in the case and the evidence, and force them to either come to an agreement, and if they have to go to a hearing, then whoever loses is going to be paying the litigation for those issues.
And Representative Weldon, thank you so much for your question. And I understand that language is to kind of deter frivolous kind of assertion to drive up the cost of litigation. I'm at the will of the committee. However, I will point out that in frivolous litigation, I think the court already has power to impose sanctions, and so that's why the language is not in the substitute I presented. But obviously, I'm at the will of the committee on that.
Well, I don't, if I could, Mr. Chairman, I don't disagree with you that there's other statutes that could apply, but I believe those other statutes may require other procedural steps in order to obtain attorney's fees, and that just further protracts litigation that probably shouldn't have happened in the first place. And this gives an incentive to do.
We won't have time to go through the discussion.
Okay.
What you're getting into as far as proposal and motion, so we'll wait and just ask questions this time.
Okay.
Next question we have will be, I believe, back to you, Mr. Lindsay, if I see correctly.
Well, I've been thrown for a loop. All of a sudden, we've now become a lose or pay state, which would be a very dangerous slippery slope for us if we
That's going to be discussions too. You got something you want to ask? We have several people want to testify.
But my point being is that in regards to the, would it not be more efficient from a judicial economy standpoint if we do go to after discovery to go to 10 days rather than 30 days? That would move the cases along more expeditiously, and certainly by the close of discovery, the defense is going to know whether or not they're going to raise that defense. That's my first question to the author.
I'll be open to that. And Representative Lindsay, you're absolutely correct. I think by close of discovery, they should know whether or not they have enough evidence to assert that defense. So I don't think just reducing that time will be that much.
Perhaps is it not true that basically discovery periods and how discovery is handled is generally done by rule of the courts. For instance, 6 months is a rule of court, not something that we set down in statute. So I would expect that would it not be reasonable to expect that the superior state courts will be handling this, would come up with some rule to handle the reopening of discovery. So that's generally a province that we've left to the courts.
We'll talk about it. If you want to discuss it again, discussing issues. I believe up here we have Mr. Welch. Is that yours?
Well, I'm sharing it with a good judge over here. He's loaned me his mic. So to try to maybe address Representative Evans' comment, on line 26, if the word within the last word of the page was struck and you inserted by no later, no later than, then it would read no later than 30 days after. And that way, you'd have all the discovery period to make whatever motion at whatever appropriate time, still reserving time in discovery if you needed it. So that may address that issue.
All right. Begin discussion. I'm trying to get y'all to, if you've got a question you want to ask of the presenter at this point in time, please limit it to that basis so we can have everybody give an opportunity. Next one would be, pardon me? Okay. And we have Mr. Mabry.
Thank you, Mr. Chairman. Representative Pat, why is non-use of the seatbelt not admissible now?
The research I done, and I actually did a pretty exhaustive search of the rules, because in the 1980s and 70s, the seatbelt was not kind of ubiquitous in every single car. At the time, there was some debate about contributory negligence statute, and apportionment statutes were not in vogue at that time.
Conversations.
So there was a distrust of kind of and the unfairness, I think, that you raised in the previous hearing on that. About omitting non-seatbelt use in cases where they didn't do anything to cause the accident. However, the recent trend, and you'll see more and more states, I know we're in a minority right now, but recent trend, what you'll see is with apportionment statutes being enacted in the states, it makes sense that the jury can consider any evidence, if there is evidence, to properly apportion fault. And right now, the statute as it existed passed at a time in a completely different circumstance and completely different policy reasons. That time has passed, and that's why you're starting to see a lot of these bills and through the state legislatures re-looking at the non-seatbelt use defense.
Mr. Chairman, if I may.
Follow up?
Yes. You mentioned unfairness. Do you think the unfairness aspect is gone away because you can't admit the ticket that the defendant got from causing the accident at the very beginning? That's not admissible, even if he's found guilty for his ticket in a criminal trial beyond a reasonable doubt. That doesn't come in. But yet and still, on the seat belt, you want that to come in, but you saying now I guess it's fair to have that come in?
Well, I think that's not really a policy decision with respect to this bill. I do think that if you want to introduce a bill to do that, certainly I think that's your prerogative. But what I'm trying to do is set down some parameters in which that the defense is available because it is relevant to the apportionment and mitigation of damages that are claimed. We're not saying you automatically have to reward that. All we're saying is that the jury may consider that. So the bill's not a threat to trying to balance the equities of what's fair and unfair. What we're doing is we're creating a framework which the evidence can come in and the jury can consider that to be consistent with our apportionment statute and the policies that we found as a General Assembly.
Thank you.
Mr. Kelly, did you have your pen? I mean, Was that yours? Was yours?
Yeah, I don't think you ever cut mine off.
Okay, I'm sorry. I thought it did. And further, we have, I believe, is this yours, Mr. Fleming?
Thank you, Mr. Chairman. My question goes to the potential substitute that Chairman Weldon offered. And you made a comment when he asked you about that we already have in the code something to deal with that. And I think I know what you're referring to, but I wanted to flesh that out a little bit so I fully understand, because I'm intrigued by this idea of how we're going to keep possibly somebody from bringing this subject up, maybe when we think it's kind of obvious and it's to delay or something like that. What kind of sanction are you referring to?
I'm talking about the stubbornly litigious section of the Civil Practice Act. And since the burden is now at clear and convincing, that you have to be very judicious in when you're going to use that. And certainly I could envision, and I see these in my practice all the time, you send a letter saying you have no basis to meet that threshold. And I feel like if you continue down this line, enforcement and get discovery, that you'll be eligible for sanctions. Just kind of the same kind of routine type of enforcement mechanism and deterrence for frivolous litigation.
I know it happens, and I'm trying to sit here and think in my 20 years if I can ever remember being party to a case where it happened, and I can't.
Mm-hmm.
Have you been party to a case where a judge actually found stubbornly
It's always been
litigious?
awarded. Matter of fact, not for stubbornly litigious, but the other statute. I can't remember.
Faith.
Right, and we were awarded attorney's fees.
You mean if you bring in a bad faith case?
Right.
Okay, but for the judge, we're talking about for your resolution as an alternative to Chairman Weldon's request. We're talking about the judge finding stubborn litigiousness for bringing a motion.
My comment was there's a mechanism to do that. Now, I don't know the experiences of all the times that it's awarded, but I do know that there's case law that actually exists defining that. So it must occur in some occasions, and I don't know what frequency that does happen.
Thank you.
And is it Mr. Weldon? You have a question?
Yes, Mr. Chairman. To the author, this bill would apply to vehicles that if I was sitting in the front seat of a vehicle that's an antique vehicle that doesn't have a seat belt in it, and I was injured in a crash, then and I clearly wasn't wearing a seat belt because the vehicle didn't have a seat belt in it, that would be this would go if they could make opposing party could make a motion. Judge would find clearly and convincingly that I wasn't wearing one because one didn't exist in the vehicle, and then that would go toward mitigation of damages, even though I or the driver of the vehicle was not at fault. Is that right?
That's incorrect, Representative Walden. If you look at line 11 to 12, if you look at the way it's written in the existing language, it requires the passenger vehicle which has a safety seatbelt.
Okay.
So that would exclude the scenario that you've outlined.
Okay.
All right. No further questions of Mr. Pack. I think we've got several people, Mr. Pack, who would like to. Yes, ma'am. Who was it? Somebody else? Oh, I thought somebody said something. Excuse me. Who would like to address the committee on House Bill 504? Start where you want to. You care, Mr. Clark? You want to do anything? Or
Mr. Chairman, I think the members have heard plenty from us on this
all right.
issue.
Anybody else? Anybody else wish to address the committee on House Bill 504? If there is, I need to have you stand up so I can see you. I can't. Nobody. My goodness, I'm shocked. Late. All right. We'll cut off further public comments. The bill is now in the breast of the committee. Do we have discussion among committee members? And please press your buttons. And we do have Ms. Oliver. Is that yours?
Yes, sir.
Please.
I came to support 504 and its subcommittee passage based on the reality. I think this is the reality that only 8% of people don't wear their seat belts now, and
2011, 7%.
it's going down. And for the 7% who don't wear, where it might be disputed, I'm thinking pragmatically, that the evidence is going to be clear half of those, or more than half. And this kind of idea of cars having a black box that'll tell us definitively. And the fact that the evidence is going to be so compelling, I mean, we're dealing with cases where the evidence really is going to be, a few cases where it's really going to be confusing, that we're really going to protect the jury. 30 states don't allow this evidence in because of the presidential nature. My question really, for discussion purposes, is I don't know what the standard is on your amendment in relation to attorney fees. It's definitely different than stubborn and litigious, but I don't think it's loser pay. Well,
It says May.
it says May. It says May on line 29.
You're open to discuss back. You want to comment back? Let me ask this. If you let me stop. If you're finished with your comments, Ms. Oliver, I'll let anyone respond to your comments and not get into a back and forth because we'll have 2 or 3 people trying to talk at the same time.
My comment only relates to the question of I don't know the standard on the attorney fee because I believe it is a May issue.
All right. Now next we'll have, please, over here. Is that yours, Mr. Weldon?
Yes, Your Honor.
Oh, Your Honor.
Mr. Chairman. Pardon me, judges.
trying to do a rodeo
I was
job.
thinking about Judge Gosselin over there, some issues we've been dealing with. I would like to comment on that. I think that in the modification line 28 through 31 that I'm offering, that the may in there would leave it up to the preponderance of the evidence, and the judge decides. And I think that's the standard in a civil case. Then I think it's up to the judge's discretion.
All right. And now, Mr. Lindsay, excuse me.
Well, the reason for my comment on loser pay is that there is no standard here. It simply says May, which means that a judge would have the discretion. Let's just say that, and I have done these sort of cases. My case is going to be very serious, involving death or very serious injury. Let's just say that I go into court believing that I've got sufficient evidence to establish that the seatbelt wasn't being worn. But the court determines that, no, Mr. Lindsay, you proved by a preponderance of the evidence, but you didn't prove it by clear and convincing, so I'm not going to let it in. Without any kind of standard whatsoever, a judge has total discretion on the use of this bill, even though I cleared a preponderance of the evidence standard, but didn't make clear and convincing. The judge has discretion as to hit me with attorney fees. That is pleasing the judicial system, and quite frankly, shutting out a defendant from being able to raise a reasonable defense. I've spent 10 years down here trying to make sure that the courthouse doors stay open, and that parties are able to play on a level playing field. And I've fought bills that I thought harmed the plaintiffs and kept them out of the courthouse, and I think that amendment, quite frankly, shuts the defendant out from raising a reasonable defense with a very high standard. Now, we can debate whether or not he should be coming in at all. That's another issue, and you raise that issue. But if we're going to have this as an issue in the court, we ought to allow a defendant to be able to raise it before a judge, provided that he's got evidence to support it. Now, clearly, if he doesn't have any evidence to support it, he shouldn't be doing so. That's one reason why I wanted to short it from 30 to 10 days, because I didn't want to delay the plaintiff from being able to get into
Tell him to get his proposed amendment published, so we'll see it in writing.
Simply putting May in here, this is a dangerous precedent for a group that has always fought to keep the courthouse door open.
Is the phone? Yes. I'm sorry. Okay. I didn't. Thank you. Next we would have, I believe, is Mr. Mabra.
Thank you, Mr. Chairman. Representative Lindsay, I see exactly what you're saying, but I try these cases on the other side too as well. But I want to make a point. What if it's used as another arrow in the quiver? What if the victim goes in, knocked unconscious, makes some statement, it's in the medical records, that wasn't wearing a seatbelt, they don't know they're, discombobulated, but a defense attorney gets that information and said, well, I saw a witness when she drove by. I think I got enough to meet the standard. And they go in and saying, hey, this, and they have depositions, all the evidence to the contrary. But because they have a little nail to hang their hat on, now we have these motions. Now we're taking up the court's time. Now we're before the judge. Now we're having to bring in experts, depose all these. So we're adding a lot of extra stuff to this. When if we have something like May, the judge could say, no, you knew that it was clear and convincing standard, and you came into my courtroom with this type of evidence. Shame on you for taking up my time when I could have been on my criminal docket, when I could have been handling other things on my calendar that I need to take care of for the citizens of this county. So we need something to combat that, because you will have defense attorneys use this as an arrow to stall, to get before the judge, just to delay tactics and to come before the court. So I think it cuts both ways, and we need the judge to have the power to police this.
All right. Next, I will give you a moment. We're going to give everybody a chance to speak. Next will be Mr. Fleming.
I'll pass now, Mr. Chairman.
All right. Back on this side again, we have, I believe, Mr. Jacobs.
Yeah, I mean, I would just say to that I think May doesn't just sweep. I agree with Representative Lindsay. I think May doesn't just sweep in your example, Representative Mabra, of the one nail to hang your hat on. I mean, I think that's an example of where, with a more tightly worded rule on attorney's fees, it may be appropriate to award attorney's fees. The problem here is that and of course, I mean, that's never been really the way we operate in as litigants in Georgia anyway. I mean, we're not a loser pays state, but the reality is that May does sweep in Representative Lindsay's example of someone who's got a meritorious defense. It may potentially rise above the level of preponderance of the evidence, but not meet the standard of clear and convincing. And remember, the flip side then of court having discretion is that the standard on review is abuse of discretion, and that's a big playing field. So I think this is I agree with Representative Lindsay. I think this is a dangerous road to head down.
All right. And I believe back to Mr. Lindsay on this side.
In response to the representative comment, when did we become afraid to have questions of fact decided by a judge or a jury? When did we decide that even though that there's even underneath your scenario, where there is a legitimate piece of evidence to support a defense, when did we stop being so afraid that of an outcome that we don't want to allow a question of fact to be decided by either a judge or a jury? That's slamming the courthouse door shut on a party. That's starting to bar someone's access to the court. That's something, quite frankly, that a lot of folks in this room have fought very hard to keep from happening. We've dealt with this issue on a lot of different levels. But even underneath your scenario, and I agree, it wouldn't meet clear and convincing evidence. But even underneath your scenario, that's a question of fact. And a question, as long as there is a legitimate question of fact out there, I think that a party should have a right to raise it. Now, and that goes for the plaintiff or for the defense. And we're getting into an awfully dangerous area when we start creating a playing field out there with even a legitimate difference of opinion, or where there are legitimate questions of fact that ought to go before a judge and jury. You can't raise it without the fear of attorney's fees. Now, I agree, if there's no admissible evidence whatsoever, no one should be raising it. But if there is admissible evidence, let the judge decide these things and the jury decide these things. That's what the courthouse was there for.
Ms. Evans.
Thank you, Mr. Chairman. I don't share the concern that we are going to shut down the courthouse doors to defendants if we pass the amendment, because the use of the word may, but also because I trust our judges that if the defendant came into that hearing with evidence that was reasonable for that person to believe that they didn't believe the plaintiff was wearing their seatbelt, but perhaps it just didn't reach that clear and convincing standard, I don't think any judge is going to pound down the hammer and award fees. That's where the may comes in, and I do think it's extremely important. we're changing a long-standing precedent in the state to allow this evidence, which I think most people would agree, whether you believe it should go in or not go in. People have very strong opinions about seatbelt use, and so there is prejudicial value that will come with this evidence. And since we're talking about only 7% of the population or so that we think are not wearing seatbelts, what we're trying to do, what I think Representative Weldon, and I don't need to speak for him, but the reason I would support this language in the amendment is because we don't want there to be a boilerplate, run-of-the-mill defense thrown up in an answer to every complaint that says the plaintiff, I believe the plaintiff, there's evidence that the plaintiff was not wearing their seatbelt, or there's a belief that the plaintiff was not wearing their seatbelt, which is enough to keep the case going perhaps a lot longer than it should. And having this language in there that if you defendant put in your answer that the plaintiff was not wearing a seatbelt and you don't really have any evidence of that, you're going to have to pay. And so it will prevent those defendants from doing that in the first place and prolonging litigation that probably should be resolved even ahead of discovery.
We'll try and keep the conversation moving a little quicker if we can. I'm going to give everybody a chance if we possibly can. Mr. Weldon, you have not spoken yet.
Thank you, Mr. Chairman. I appreciate the comments that are made there by Representative Lindsay. I just don't agree. I think that the modification that we're offering and we're asking be included in the bill, it applies evenly to both. This is and I think it's fair and it's just and it's equally, when it's equally applied, then that's when you have the best results in a court of law. Now, with respect to your comments regarding the word may, we elect Superior Court judges and state court judges for the purpose of making difficult decisions and making decisions with respect to the litigants that come before them. There's been times when I've had cases that I thought I should have won, and ones that I thought I never should have been close. But you know, those were fortunate days and few and far between. I worked hard to try to make sure that this was a balanced approach toward addressing the issues when it comes to bringing these things. And this could be used by either party, and it could be used as a way to, to protract the litigation by either party. And this gives the judge, the one that's been elected and the one that's been placed in the position of making those decisions, the opportunity to exercise that discretion. And I think our system is set up for the purpose of them making those discretionary decisions, and they need to exercise them. That's what they get paid to do.
Thank you. Mr. Lindsay, I'll give you another
my last comment. I find it fascinating, Representative, that 10 minutes ago you were worried about the judge abusing discretion when it came to reopening discovery. And I believe your comment was, well, we've got some great judges, but they're not always great. And then 10 minutes later, in defense of this motion, rather this amendment, you're telling me that you have full faith in all judges to do the right thing here, despite the fact that there's no standard being placed in there. Quite frankly, that seems a bit contradictory. In regards to the applying equally to both sides, Representative Weldon, quite frankly, if it was a preponderance of the evidence standard as to whether or not the judge allows it in or not, I might agree with you, because that's just more likely than not. But when you've got a clear and convincing standard that a defendant has to raise, and you're going to say if he doesn't get all the way up to that mountaintop, we're going to hit him with attorney's fees, or may hit him with attorney's fees, that's not a level playing field. That's not applying equally to both sides. That's attempting to freeze out a party from raising a reasonable defense. And that's my last say on that, Mr. Chairman.
Okay.
But this is a disappointing amendment. I got to tell you.
Thank you. Let's come back to you, Mr. Mabry. You have your button pushed again.
Yes, Mr. Chairman. Just a quick point, Representative. By allowing, if you have any evidence of non-use of the seatbelt without having the judge to be able to balance sort of the scales. Why not file? Why not file a motion? What's going to stop anyone, any single piece of evidence of non-seatbelt use? What's to stop that motion from coming? Nothing. It's going to come. There's nothing. It's going to come. Win, lose, and as Representative Weldon said, sometimes you get lucky, sometimes you don't. Who knows? If you got a piece and you can get in front of the courtroom, in front of that judge, who knows what's going to happen? You could meet that standard, you may not. But that's why that motion will come, because as Representative Weldon said, hey, I won some, I should have lost. I lost some, I should have won. File the motion, and they're going to come on every case, unless we have good judges up there to say, we're not going to allow this in the courtroom. My last words.
All right. Thank you. And yours, Ms. Evans, one more opportunity.
Thank you, Mr. Chairman. Just briefly, to Representative Lindsay's point about my alleged contradictory statements, they were not. My question about the timing of the being able to name an expert was made because I said I don't know. My point is, I think, and I still think, and it sounds like maybe I'm wrong, but my thought is that the rules are very specific about when you have to name your expert. And so I don't think a judge would be abusing his or her discretion to say, you knew this was a possibility that you were going to have to raise evidence on this issue for a jury trial, and if you didn't plan in advance and pay for an expert, shame on you. I'm not going to delay this trial for you to get an expert. This, what we're talking about in this proposed amendment, is may for the judge. It is very clear that it is discretion. I was worried about a judge enforcing the rules of civil procedure, which I think I'm now wrong on. That is the difference, and I do not think I was being contradictory at all.
Thank you, ma'am. Anyone else wish to comment? Even those who are back against the wall, Mr. Powell, you haven't said a word. Okay. Not until we finish discussion. We're doing discussions first, and we'll take motions. And no other discussion. I'm going to close out discussions. I'm glad we have the bill before us. I felt that what we had put together here came out of a subcommittee discussion where I was present, and Mr. Clark raised the issue about having a higher standard as a means of being sure before there is this issue to go to the fact finder that the court has cleared that hurdle by looking at clear and convincing evidence. I think you suggested that, did you not, Mr. Clark? And I felt that was an appropriate thing to do, because we did not want to have the Donnybrook of every case being tried, first of all, with the issue of did you or did you not wear a seatbelt, going to the question before the fact finder until it's been at least established by a higher standard than what we normally have by preponderance of evidence. I don't know of anything else we do in the law where we stop in the middle of a trial and start awarding damages or awarding attorney's fees as a part of what we consider to be the civil procedure of having a case prepared to go to the fact finder. And I think we're trying to signal out here something that is by itself unique. And I don't know if we want to get into that situation. What if we had the same on the reverse side, saying the evidence is going to go in by a party to say there was not a seatbelt on, and then you had the high standard saying, no, the party who's claiming they wore a seatbelt has got to show by clear and convincing evidence they did wear a seatbelt. If you didn't prove that, you'd have to pay attorney's fees. I mean, to have it the same way, we don't do that as a part of civil litigation. We recognize that, we have a lot of frivolous motions filed by parties, plaintiff or defendant. You have, I think, a lot of these motions in limine we use to try and exclude evidence. Some of them are, quote, frivolous, but you have to go in and do battle before the judge about even that type of motion. So I guess I have concern where we're trying to signal out in this particular case, if we have this bill to pass, we're going to have a unique situation established when a party has a need to prove by clear and convincing evidence as standard. Beyond that point, I think we're dealing with something. To me, it's not something that is foreign. That we've had a law in the books for a number of years, recognizing that the failure to wear a seatbelt is, in fact, a violation of the law. Everything else we do in the operation of a motor vehicle by individuals comes to a standpoint, if you do something violating the law, it's going to be evidence that can be considered by the fact finder as to causation and then damages. Is that correct? I'm asking each of you lawyers look at it. Everything we do recognizes causation and then causation related to damages. And the fact that, we don't bring in the fact of a person being charged. We do that for a very logical reason. A lot of times the issuing of a citation isn't based upon the issue of negligence. It may have been what the particular police officer, law enforcement officer, finds from what he sees in the debris on the road and makes a decision about it. But it doesn't mean that in and of itself is what is the proof of it, unless the person then admits guilt. Their admission of guilt becomes a matter of proof of the negligence because they said, I did something wrong. But this is not having just the right to say that a person who failed to wear a seatbelt is a high standard applied to it. To me, with public policy that we have, I don't know why it's such a problem. And as you point out, it is a normal thing in the various states that Mr. Pack, you talked about history-wise. I know the states in recent years more and more have come around to recognize, because we do have, we started out, you had to buckle up a seat belt. It's kind of hard to even find it, and then you started having what we call these automatic seat belts that were causing other injuries. They quit doing that, so now you do have to bring around the lap and harness type to secure yourself in a seat. And it's to me just the fact that if you're not wearing that seat belt, you have violated the laws of Georgia. We're not going to recognize that as far as looking at when someone's damaged. That damage may be partially attributable to their failure to obey the law. Let's do away with seatbelt laws. Don't you keep carrying something on the books that is not going to be recognized as a violation of the stated policy of the state. We're going to have this time. Chair will entertain motions. Do we have a motion? It's been moved to pass. Do we have a second? It's been seconded. We have discussion on that motion. Do we have amendments to the motion? You have amendment, Mr. Weldon.
Mr. Chairman, I move that that House Bill 504 be amended by substitute, and we prepared to substitute LC 295950S that I believe has been distributed to all of the members of the committee.
Yes, sir.
And it's the only, pardon? What? Well, I want to do an amendment, Your Honor. Your Honor.
All right,
Mr. Chairman, it's been a long day.
Give me your amendment.
The amendment would be at the end of on line 28.
Right.
On LC 295954S.
Read your amendment.
Would be after the words "these issues," period, insert the following language: if these issues are not resolved prior to a hearing on such motion, comma, the prevailing party may be entitled to recover from the opposing party reasonable attorney's fees and expensive litigation incurred in connection with litigation of these issues, period.
And these issues being the issues of the seatbelt, correct?
Correct.
Okay. That's the motion stated. Is there a second to the motion? Second. It's been seconded. Discussion on the motion. Do we have any discussion? I'm trying to look around. It's got whose lights on? Do you have discussion, Mr. Jacobs? Okay, no discussion on the motion. All in favor of the Weldon motion amendment, rather, signify by saying aye.
Aye.
Opposed, like sign.
No.
The chair is in doubt. Chair will call for a show of hands. All those in favor of the amendment signify by raising your right hand and take account. All those, do I count 8? All those opposed, raise your right hand. 5. Motion carries 8-5. Any further amendments to the bill? Mr. Lindsay.
Yes, Mr. Chairman. If I understand where we are, I want to change what is presently line 27, where it says 30 days after. So 30 days prior, strike that, and put in its place 10 days after.
So not later than
10 days after.
All right, let's
the
look
end.
at this.
Go from 30 days prior to, cut that, and insert in its place 10 days after.
May I make a suggestion?
Yes, sir.
On the prior page, line 26, shall file a motion not later than 10 days.
Yes, sir. Yes,
So
sir.
make not later than as opposed to within. Would that be your motion?
Yes, sir.
And use 10 days.
Second motion.
All right, there has been a motion made amending and starting on line 26, strike within at the end, and the 30 days, and we'll say within, not later than 10 days after the end of the time allowed for discovery, etc. That's stated the motion. Yes, sir. Mr. Jacobs?
Personally, I'm not a fan of such a short fuse on a motion after discovery. I'm going to make, and we'll see if it flies. I'm going to make a motion to amend the amendment to strike 10 and make it 30.
All right, so we got first of all a motion to amend the amendment, changing the 10 under the amendment of the motion back to 30. Any discussion on that? If not, the chair will call the question. All in favor of 30, as stated by Mr. Jacobs' motion, signify by saying aye.
Aye.
Opposed, like sign.
No.
Chair rules the motion to amend the amendment passes. Back to the original question, Mr. Lindsay's, which is now to file a motion not later than 30 days after the end of the time of discovery, etc. Is that correct to state your motion as amended?
Yes, sir.
All in favor of the Lindsay motion as amended, signify by saying aye.
Aye.
Opposed, like sign. Motion carries. Any further amendments? Not the chair. You do have an amendment, Ms. Evans?
I think so. I still have concern that there may be discovery rules that prevent the introduction of expert testimony, and I very well could be wrong, and I'm just not sure, but I would hate for us to pass a law that then keeps a passenger from introducing the evidence. So I make this amendment in that vein, and it would be to add at the end of line what used to be line 28. I don't know if it still is anymore.
These issues, it is. We have, you want at the end of the sentence that ends these issues at line 28.
And that's where the amendment.
That's where his amendment came in. You want to add something? Let's stop. Let me clarify.
I guess
If
at
you
the
want to
end
add
of
something
two,
at that
sorry.
point before the amendment that came in from Mr. Weldon, is that what you're trying to do?
Yes.
At the point? All
Yes.
right. Read your amendment. Proposed.
The proposed amendment is if the court finds by clear and convincing evidence that the passenger was not wearing a seatbelt at the time the injuries occurred, comma, the passenger shall not be precluded from identifying fact or expert witnesses on the issue of damages.
I think it's a little wordy. I think we could.
And it could be cleaned up, I'm sure. I can give you this. You can read it.
You have it. Okay.
Yeah, the parties. It could be the parties. But I think the defendant probably already had their expert at the hearing. But I don't disagree with what you're saying.
But you're talking about damages. The hearing
Right.
is going to be just the issue of
Fair point. Fair point. Yes, parties. Evidence.
Why don't we say if the court admits evidence as to failure to wear a seatbelt? That's what you're talking about.
That's true.
Yeah, if the court grants the
Yeah,
motion.
that works. parties shall not be precluded.
Parties shall not be precluded from identifying facts or expert witnesses on the issue of damages.
Yeah, I meant fact or expert witnesses, lay or expert witnesses, however it should be.
Can you say fact or witnesses? Because you're going to witnesses.
Well, no, I was saying a fact witness or an expert witness.
Let's say witnesses.
You could just say witnesses.
I guess I go back. I'm not. If that's your motion, we got judges here know better than I do. You're not precluded at any time to bringing in additional witnesses. If you have something that comes in as a matter of this level, that say, okay, the court's ruled that there's going to be this evidence admitted, and that changes your need to have a witness, you can get expert or other witnesses, lay witnesses, up at any time until time of trial. You certainly have it up until time of a pretrial order.
Given that
No
we've
question.
left the time period open for 30 days after.
It's not different. Different discovery, pretrial orders.
Right. No, I understand. But since we're talking about, is it possible that there would be a pretrial order?
Not unless the court has ordered to have one, and then I say you can always. I guess even after that point, if you have need to show that you have required a witness to answer something, it's a matter of letting the court know. Maybe Mr. Lindsay can answer my point. You never preclude.
I think that the representative's concerns are valid, because I could easily see where a court would enter a pretrial order and leave this issue open for pretrial motions. I could easily see where that
All right.
judge could do that.
Could happen. All right, Mr. Lehman, do you want to say something?
Yes, sir, Mr. Chairman. I'm trying to comprehend Ms. Evans' amendment, and here's my fear. She's saying shall, the court shall allow. Well, I wonder at that point going forward, you're taking away the court's discretion to say, why not in the middle of the trial? Go get you an expert. Because you shall allow. There's no limit on the shall. Shall not be precluded from?
In Representative Fleming or Vice Chairman Fleming, I would certainly be amenable to saying shall not be precluded from identifying witnesses prior to trial. I mean, I certainly don't want, I'm not trying for anybody to be able to be surprised. I'm just trying to prevent folks from having to go out and hire experts early just in case.
But at that point, and correct me if I'm wrong, you're still instructing the court, except for Monday when trial starts on the Friday before, you've got to be able to bring in a new expert.
Yes. We're
Now,
saying that the plaintiff
that
should not be precluded from basically responding to the finding that the seatbelt evidence is going to be admitted.
Friday before trial, they can bring in an expert. Is the other side going to be able to depose that expert?
I'm doing this on the fly. I mean, I'm not opposed to trying to put in some safeguards, but I'm very concerned that we might be.
All right. State the motion again.
If the court grants the motion, parties shall not be precluded from identifying witnesses on issues of damages.
That's the motion. Is there a second to the motion?
I'll second.
Second. Discussion on the motion. Mr. Lindsay?
Would it help with folks' concern if you added within a reasonable period prior to trial?
What's reasonable, I guess, is
that's going to be up to the court's discretion. But would that?
I accept that.
Yeah.
Yes.
Yeah, before trial.
You accept that as a friendly amendment to your motion?
Yes, Mr. Chairman.
Why don't you restate the motion with the proposed change to it? We'll call it same motion for amendment.
If the court grants the motion, the parties shall not be precluded from identifying witnesses on the issue of damages within a reasonable time prior to trial.
Thank you. That's the stated motion, and still have a second.
Second.
All right, and any further discussion on the motion? All in favor of the motion signify by saying aye. Aye. Opposed, like sign. Motion carries. Any further amendments? No further amendments. The chair call the main question, which is a due pass to House Bill 504 as amended as a committee substitute. All in favor signify by saying aye. Aye. Opposed, like sign. No. Motion carries. Thank you. We're back now. The last thing we have to do, I want to. Yes, sir. Mr. Fleming's got an announcement.
We are going to take up the next bill, right, Mr. Chairman?
We are. Got to take up the.
We were scheduled to
e-discovery.
have my subcommittee meet after full judiciary, but that was pending when we got through, and obviously it's going to be very late. So we're going to cancel the subcommittee meeting, Fleming subcommittee.
Last matter of business we have is House Bill 643. There will not be any further public comments on that or statements. There will be a review of the draft bill as prepared by Legislative Council. We're looking at LC 2959. Let's get the door closed, please. You want to stay in here? I'll give you a quick time to get out, or need to shut the door. Too much noise coming in. Too much noise coming in. Ask to move away from the door, please, Mr. Lindsay. All right, everybody out? We'll go forward with LC 295941 ERS, and I'll ask Ms. Travis if you can bring us up to date what happened as far as the changes in the bill.
All of the amendments that were offered at the last hearing were worked into this substitute.
Okay.
They were the two legal amendments having to do with medical records.
If you can, point out so we'll have a little guidance where we're going with the changes that have been previously made. All right.
So on page 19,
Ask them to move away from the door. Move away from the door.
the language at line 659 to 666 were added.
659, when electronically stored information is capable of being produced in both physical and electronic formats, production of the physical copy shall be sufficient for compliance with the subpoena, period. That portion. All right.
With respect to I know it was the Evans, the Welch, and the Lindsay amendment. So the next place that I can think of is on page 11 at line 363 to 365, having to do with expenses. That also
The
had to
court
do,
should, yeah.
actually through 368, it had to do with, we changed the language, we said from production to include retrieval, production, conversion, etc. It had
Correct.
to do with the medical amendment.
All right. The reason I'm asking this, we're not going to go back and have any further amendments to what has been amended. Okay? And I may have caught you off guard. I thought you had a copy that I'd asked you. I understand.
Previously.
I understand.
I believe at page 4, at lines 111 through 135, there were a number of changes, and I can't remember the author. I want to say it was either Representative Welch or Representative Evans that had amendments having to do with changing this to be more conforming to the federal rules.
Correct.
I'm sorry, I think that's all I can remember.
Okay. Well, I said my reason for inquiring was just to try and limit what we're going to be changing. Don't go back to change what we've already amended. As a practical matter. Who knows? Do we have further amendments? I think we've got some in the folder. I'll recognize Mr. Jacobs. Find which amendment number-wise you're looking at.
judi022014EDITED, the Coomer Amendment.
And that takes us to lines 259.
And Mr. Chairman, if I may, a parliamentary inquiry first.
Yes, sir.
I know that the chair preferred to have paper amendments. As I look at the Coomer Amendment, there may be a couple of other places where a word could be inserted or a couple of words changed to clarify the permissive nature of what Representative Coomer is trying to effectuate here. Would the chair be willing to entertain very minor amendments?
I'll open to it, yeah. As long as we get a long verbiage, we're not on.
All right.
Let's have something to look at.
Well,
tell me what you're doing with the amendment 2273.
Well, this would change. This would basically make the process after failure to agree on a discovery plan at the discovery meeting permissive from the court standpoint. These are changing those. So the court would then have discretion to complete the process if it appears to the court that completing the process of getting a discovery plan in place is not necessary. The court then would have that discretion.
So what you'd have is, even though a party files a motion where they have not been able to get to an agreement, it doesn't mean the court, by factor of the motion being filed, is under a duty then to enter an order.
That's correct. So it would change the word shall the may on lines 259, 261, and 266.
259, 261,
and 266.
And was the third one 266?
Six.
Excuse me. All right. Does everyone have that motion understood? In discussion on the motion, we'll call for the Jacobs motion, or the Coomer motion, right?
Jacobs, Coomer. Coomer, Jacobs.
All in favor of the amendment signify by saying aye. Aye. Opposed, like sign. That motion carries. You have further amendments.
I do, Mr. Chairman.
Jacobs.
I would suggest that on line 212.
What number are you looking at?
This is not. I'm sorry. These are the two other little cleanup amendments that I'd like to present. On line 212, because we call this creature a discovery meeting throughout the rest of this subsection, I think at the outset we ought to call it a discovery meeting. So it would be on line 212, insert the word discovery before meeting.
Well, you guys saying a meeting on the subject of discovery.
Oh, sorry. I'm
that
sorry.
Tells us what
Okay. No, never mind. Strike that one.
Okay.
The other one would be on line. It's late, right, Representative Weldon? And then clear and convincing that it's late. 258. I think here it would make sense to, instead of having and again, this goes to the court's discretion, instead of having the court then hold a mandatory hearing upon motion of a party, I certainly would invite others to suggest that this should not be the case, but I think it would be better for it to be upon order of the court instead of upon motion of any party, so that a party could move.
Well, I think that's what starts the process, isn't it? The court has to have something brought to its attention through a motion.
Right,
and from that motion it would then direct the parties to appear.
But this leaves the court, the way it's written now, leaves the court, upon filing of that motion, no discretion to decline to hold the hearing.
Well, it said may order entry of an order. Well, we already changed that once.
Well, no, I think the most logical way to do it would be
may be required to appear before the court for a discovery conference at which the court may order. I mean, it's obvious that the court is not going to order. Doesn't enter an order. I'm not.
Okay, well,
short circuit. I think the intent there is that you file a motion. Now the court may look at it and say, well, file your reason why, make a decision, come into court for a further conference on the discovery plan, or saying we're not going to do it.
all right. How about this then? On line 258, insert the words. I'm sorry, line 258, delete the word shall, but leave the comma. And after the comma, but before the word appear, insert may be ordered to. So it would read, the parties, comma, upon motion of any party, comma, may be ordered to appear before the court.
All right. So we're going to have may be ordered to inserted before appear. Hold on. We're going to discuss it. I'm not through. Just want to be sure I got it stated. Mr. Weldon.
Thank you, Mr. Chairman. The to the author of the amendment, I'm not sure this is necessary. Just thinking about procedure, if I'm engaged in a case and we can't get along regarding discovery, and I make a motion for a discovery plan hearing, then I'm going to file a motion asking the court to require the parties to engage in require the court to enter an order for a discovery plan. And then I'm going to serve a Rule 9 side or a notice of motion. I'm going to set it down on a day, either if it's a circuit day, like in my district, where they don't assign judges, or if it goes to a circuit that they do assign judges, then somebody's got to get with the court clerk or the court's office and schedule that, put it in the notice of motion. You're going to come before the court. And I don't, to me, this adds another, it has to be a Rule 9 side requiring everybody to appear for the motion, but it just seems like that's not necessary, and it's duplicative.
Right,
if we accept the amendment, I guess I don't understand the point of.
The point is that the court, considering the motions that are submitted, may look at them and say, we don't need to do this, and decline to hold the hearing.
But without the amendment, the court
the way this is worded right now, if one party files that motion, there's going to be a hearing. Even if it's a ridiculous motion.
I think he's got a good motion as well. My thoughts. Other discussions on the motion.
You heard that?
Other discussions on the motion. Jacob's motion for amendment number 2. Do we have a second? It's been seconded. Any further discussion? If not, the chair will call the question on Jacob's amendment number 2. All in favor signify by saying aye.
Aye.
Opposed, like sign. Motion carries. One no. Mr. Jacobs, anything else? Do we have other motions for amendments? Other proposed amendments? I have one. I have two, I think, actually. The first one I've got is on the line 143. This goes back to, I wasn't aware we changed this, but I want to talk about it. We had this discussion, and this is under may promptly present the information to the court under seal for determination of the claim. We don't usually submit documents for review of the court under seal. What you do is have a court, make a review. I'm going to talk about my amendment. I'm sorry. The amendment we're looking at is going to be 2274. Really what the court would be doing is having an in-camera review of documents and not receiving documents under a seal. The court would only be sealing documents that are to be a part of the record, to be no longer open to public review. So my desire is to change back where it says information to the court under seal to say may promptly present the information to court for in-camera review. That should be for in-camera review. For determination of the claim. That's the motion. Motion seconded. All in favor of the motion signify by saying aye. Opposed, like sign. Motion carries. I said on line 143, strike under seal, information to the court for in-camera review for determination of the claim. The next thing I have is looking at the enactment dates back on section 9. We currently have, this is not a written one, but I'm speaking for the amendment, the act shall become effective on January 1, 2015 and shall apply to all civil actions filed on and after such date. I personally believe that all things that deal with the matter of the procedural law in Georgia, as it always has been, I think, in the past when we deal with procedural matters, it doesn't address an action filing date, but addresses what is the enactment of the law date, and I would be in favor of saying the act shall become effective as of January 1, 2015, period. Mr. Lindsay.
The reason, Mr. Chairman, why we struggle with this was, what do you do if you've got a party who has filed for discovery, received discovery back underneath the old rules in the middle of the case, and then someone moves to compel or moves for sanctions underneath the new rules?
And that's what we got judges for.
We've been through this one already.
I think somebody talked about that earlier. That's what we got judges for.
I think we've been down this road already.
I mean, that's the whole point about it. You know, they say I've got to open back up my discovery. The law's changed. I've got a right to do something with e-discovery that I didn't perhaps have before. Then they have that as a matter addressed to court.
But what if someone believed they were complying underneath the old rules, but may not be complying underneath the new rules?
And that's, again, addresses the matter of the court, look at it and hear the position of the parties. Mr. Jacobs. Go ahead. Yeah, I'm gonna say
well, I mean, it's a rare day that I disagree with Chairman Willard. You know, the bill really goes beyond e-discovery. I mean, I know it's been called the e-discovery bill throughout the process of going through subcommittee and full committee, but I mean, it touches on many different aspects of the discovery process, and ultimately, I mean, it's my belief that if the rules of engagement for discovery are going to change, they ought not change midstream in a case. And so I certainly understand what the chairman is saying, but given the breadth of this particular bill, I think that having a clear line of demarcation with regard to the filing date of the case, so that the rules of the road stay the same on either side of that line, I think is the best way to go.
Here's what you're going to face with that. You're going to have two published parts of the book. They're going to address for how knows how many years, just like we did at one time with the probate law. And it goes back and forth trying to decide what particular section of this law will apply to the case I have pending. Because as you point out, there may be sections in there that are changed that may not specifically apply to e-discovery, yes. But you're going to have a whole raft of things where you're trying to refer back and forth based upon the date of your filing of an action as to which law is going to be applicable to you in that circumstance. And that's I think, an untenable thing to try and work under for lawyers as well as the court, the parties. And I think what you're looking at here is what you need to say is we're doing all procedural matters as of a certain date. This will be the law applicable to how cases are handled before the court. We're not changing or divesting of any statutory limitations or rights of the parties as to their recovery. What we're saying is how the case is going to be proceeding before the court and what law will be applicable to that process. I think otherwise, to me, it's going to be untenable to try and distinguish over several years what piece of the law is going to apply to your particular case. We have a second to that motion. Anybody wants to? You have a statement on that, Ms. Evans?
Yes, Mr. Chairman, just briefly. I started out in agreement with Representative Lindsay and Chairman Jacobs mostly because I feel like because I believe in the great discretion of our judges, but in worrying about what the parties being able to rely on what the law is going to be or not be, that's why I had agreed with them. But then I think you raised a very good point about cases being published in the meantime on these discovery rules, and would propose just as consideration perhaps an effective date of January 1, 2016 to so we don't have to worry about people worrying about their discovery being in flux. We're giving clear notice, and I believe that's how the federal rules did their when they did an overhaul, they pushed it a year out.
As of a date, that becomes all the law that applies to all the cases.
Right. So I guess I would
so
offer that as a friendly
You don't have a before and after procedural law.
Yes.
It'd be just untenable.
So I
yeah. What's your amendment? That's a long way out, but it's up to about a year. Yeah, go ahead. So you're amending the amendment to 2016. Is there a second to the amendment? Oh, I'm open. If somebody wants to propose as a second. All right. We have a second. The matter is now the motion I made was just having the effective date of this law should be as of January 1, 2015. The Evans amendment to that is to change it to 2016. Is there discussion on that motion? Did you have yours down, Mr. Fleming? Okay. We'll call for the Evans amendment to the amendment. All in favor signify by saying aye. Aye. Opposed, like sign? No. Motion fails. We're back to the main amended motion. Mr. Lindsay, do you have something you want to say to the motion?
I'm still struggling with this, Mr. Chairman, and let me give you this example and tell me why it may or may not be applicable. When we did the evidence code, for instance, we did the cutoff date, January 1st, whatever. But what we said was if a case was going on, being tried, and started before December 31st, whenever it was, and carried over, you still stayed with the old evidence code.
If they were in the process of actual trial.
Yeah, that's my point. I see that as somewhat analogous to a situation where we've got ongoing discovery, and I'm asking, and I don't know how I'm going to vote on this yet, but I just want to ask you, isn't that more closely analogous to a?
How many years we're going to be doing that though? Now, we talked about that case with evidence as to a specific circumstance. They were involved in the process of a trial during the application date. So you didn't have something right in the middle of trial where you're trying to maintain a position with the law as it was on evidence, and now something's changed on you right in the midstream. But beyond that point, it was a procedural thing that everything that applies to evidence was changed from that point on. And as I say, otherwise you're going to have, and Ms. Oliver, you've been more familiar with that, but we had for years those two probate codes trying to decide back and forth which one applied in a particular situation with the trust or with the will or guardianship. It's an untenable thing to try and do, especially with the procedural issues. That's my argument about it.
I think you can win.
You have Ms. Welch, you waive. All right, any further discussion? On that amendment, all in favor signify by saying aye.
Aye.
Opposed, like sign. Motion carries. Any other amendments? I don't know of any. If not, we're back to the main question, which is a do pass on HB 643 as amended as a committee substitute. All in, yes, sir.
I'm sorry.
Did I miss something?
I have some on my desk.
I think that was included by mistake.
We did that.
Yeah, we did that.
We've done it already.
Last.
Yeah. So all the amendments have been reviewed and motions made on them. So back to the main question, which is do pass on HB 643 under 5941 ERS as amended. Committee substitute. All in favor signify by saying aye. Opposed, like sign. Motion carries. With that, we conclude our business. I thank everyone for staying with us.